who's next? Thank you. Okay, thank you. Hello, Ms. Barnes. Good morning.
Jason McKinney on behalf of Maria Rodriguez Barnes, case number 20 CF 801. This is a case that is on the trial docket. We are ready to proceed forward with trial. She's also scheduled at 2:30 for motions limiting. I believe Assistant State Attorney Sandler is going to be here at 2:30 to argue those. So I'd ask that she be brought back at 2:30.
Okay. Ms. Barnes, I'll see you at 2:30 this afternoon. Okay. Thank you, ma'am.
Number 31 on your docket.
Thank you.
Judge, this is Ms. Whitson before the court in 24 CF 825. This is on the docket only as a bond reduction hearing in 24 CF 825.
Okay, thank you.
Yes, but 305. Addressed, okay. May I ask a few questions of Ms. Whitson?
Sure. Ms. Whitson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am.
Ma'am, could you please state your name for the record?
Melania Whitson.
In my bond motion, I said that you would be able to reside at 305 Holly Road in Destin, Florida. Is that accurate?
It is.
Who lives at that address?
Myself and my roommate.
I have no further questions.
Okay. Any questions from the state? Okay. Argument?
Judge, currently the bond is set at $25,000 cash to professional. She's been obviously unable to make that. We're asking the court to consider reducing it, even if that includes pretrial services or anything that the court deems appropriate for a lower monetary bond amount. She has lived in the area for about a year. She does have education, and I believe that she's not a flight risk.
Okay.
She's been incarcerated since April 9th of this year.
And Ms. Whitson, I did do my homework. I read through that motion and saw those different facts to the state.
This is a situation where the victim has a pretty traumatic experience. He's hit by a hammer. The input from the victim, we'd be opposed to any kind of downward reduction. Feel like that based on the situation and the way the events went down and using a hammer, it's very dangerous. And $25,000 seems to be a reasonable bond for that charge and for those facts.
Okay. I don't know if it ever really said that was a hammer in the arrest report. It said it felt like a hammer. There was also in the affidavit statements from the witnesses that talked about both sets of facts. Mr. McKinney, anything else?
No, Judge, other than the fact that I would point out that we are seeking to set depositions once we receive the discovery in the case.
Good. Okay. Ms. Whitson, all I've got as far as the facts of the case are this affidavit, the arrest report, the sworn statement, and based on that, I believe that the $25,000 is reasonable. So respectfully, your motion for bond reduction is denied.
Judge,
So-
I believe the next court date would be the July 8th.
I'll see you no later than July 8th. Thank you.
Matthew Warner, next number 28.
Thank you. Hello, Mr. Warner.
You're still- Judge, Mr. Warner's before the court. This is in 3 case numbers, and this is not set for trial. We are actively trying to resolve these cases, and I believe that we are very close. There is an unrelated but related matter related to Mr. Warner's daughter and related to DCF, and whether or not the child's going to be removed or not. So Mr. Warner is going to ask for a continuance today. It is not on the trial docket, but we would ask the state to leave the offer open until next week. We can provide communication to the state if we're going to accept the reduced offer, but he wishes for me to contact DCF to see how that's going to affect the other case.
Okay. Mr. Warner, that means that I'll see you no later than July 8th, but if the state offers you something that you want to accept next week, Mr. McKinney can set it for a hearing next week. Okay?
So
Thank you, sir.
if I may, this is a situation where we would be trying to set this on Thursday at 12:30. Is that what?
If a plea's entered, that would be the easiest thing from the court.
It shouldn't take the defense very long to get the answer, and we
Okay.
can let the state know probably by the beginning of next week. And then we can certainly schedule a court date, hopefully next week, to do that.
Good. Thank you. Thank you, sir.
Justin Wells is next, number 30.
Thank you. Hello, Mr. Wells.
Hey, how are you?
Good. How are you?
Do you have any questions? Okay. The one thing I did not write into this is the cost of supervision, because we're going to ask the court on his input for that. Does that make sense? You have a full chance to read it through? Okay. Judge, we've reached an agreement in Mr. Wells' cases. He has a mix of new cases and felony violations of probation. We did discuss this at length with the state. We did go through the score sheet. We've been provided an accurate score sheet that reflects 39.3 months Department of Corrections. This is going to be a downward departure from that. The agreement with the state at this point is for a new 11-month, 29-day Okaloosa County jail sentence with credit for time served to be followed by 3 years of probation. Special conditions of the probation include, I guess the sentence includes complete the ECLC anchored program. He's been excelling in that program and is about to phase out. Obviously, there's admission to the violations of probation, and it's concurrent between all the cases, all the counts. Court costs are $515 in the three new cases. There's a $100 VOP fee in the 3 VOP cases, and a total of $650 cost of defense. We will be reserving over the amount of restitution. And the biggest part of this agreement is that there is a suspended 60-month Department of Corrections sentence. So if he were to violate the supervision, then that suspended sentence would be hanging over his head. May I approach?
And the adjudication?
He would be adjudicated guilty. He's previously been adjudicated.
Thank you. Yes, sir. Mr. Wells, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Wells, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Wells, do you understand that if you don't successfully complete the probation, that you very easily could be sentenced to 60 months in prison?
Yes, sir.
Okay. And that is a suspended sentence?
Yes, sir.
Do you have any questions for me or your attorney or the state?
No, sir.
Mr. Wells, I do accept your plea. You're adjudicated guilty. It is a downward departure. You're sentenced to 11 months, 29 days in the Okaloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time on each case and count. That's followed by 3 years of probation. You will need to successfully complete the ECLC program, pay the $100 VOP fee, all the court costs, total of $650 public defender's fee. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition. The court does impose the 60-month DOC suspended sentence. So when I say impose, that's, at least that's part of your plea agreement. Probation, questions?
Yeah, I have a question about the probation. It was set to term on November 2024, so are we starting over? Did we
It would
revoke it?
be a new term.
Okay, so did we revoke it and do a new term? again?
Correct.
Okay.
Okay, 'cause I didn't see revoke, I didn't hear.
Yes, it would be a new term, 11/29, followed by 3 years probation, so it would be a new term of probation concurrent between all of the case numbers, the old VOPs and the new case.
Probation, great point. I didn't hear revoke either. The prior supervisions are revoked, and the 3 years of probation is a new term. They'll also you'll need to pay the $40 per month cost of supervision.
And we were going to ask the court if the court would waive all or a portion of that, since he's going to be coming out of jail and he's going to be completing the anchored program probably while he's on the probation.
Okay, I do waive it for the first 6 months that you're out. If you get to the point that you can't pay that, send a letter to the judge. It'll be a different judge next year, but say you want to modify your supervision to ask for a waiver of that in the future and give the reasons for it. Okay.
And are the original monetary conditions reimposed?
Yes, ma'am.
All the original conditions would need to be completed in the new term of probation.
Yes. Thank you. Thank you, sir. Good luck to you.
All right, thank you.
Timothy Jordan's next to Mr. Cobb.
Thank you.
Number 2 on the docket.
Thank you, ma'am.
Jason Cobb on behalf of Timothy Jordan. In his 21 case, Judge, the state and I have really gone at it with each other trying to find a way to resolve this case and back and forth. But it seems we're sort of at an impasse, and the offer is 6 years DOC, which would be a downward departure. And I've explained that to Mr. Jordan. He's rejected that, requested that he go to trial. And Mr. Gomez informed me that the 6-year offer will be withdrawn tomorrow at 12 o'clock.
Okay.
If we can get just that exposure for, because the offer was for 6 years for all of the cases. I just kind of want to make sure that he understands that as of right now, his lowest permissible prison sentence is around 135 months in the Department of Corrections, which means that in order, if he were to be found convicted, there would have to be grounds for a downward departure. With that, part of that would be a 3-year minimum on the 23 case. I just want that to be on the record so that he understands the exposure. I mean, the exposure is much higher than that, but I just want him to be aware so that we can make good record that he wasn't aware of that information before turning it down.
Okay.
On
Mr.
that
Cobb.
note, yes, sir. I know that if we go to trial on the 21, he's acquitted and or convicted. He still has the 22, 23 cases. But I mean, if we get convicted on the 21 case and we did proceed to sentencing, until we resolve those other cases, I don't know how they could be calculated into the score sheet to be sentenced on the 21 case. So I don't know if that affects what his total lowest permissible is, but I do know that one of the reasons we're having such a hard time coming to an agreement in this case is prior criminal history and score sheet. His prior record just kicks it out automatically, basically, up to scoring prison. But everything Mr. Gomez said is correct.
If the court can add the other cases, can keep them all together, then it's 135 months.
Yes, sir.
Okay, I understand your argument.
Correct. And I don't know if we'd proceed to sentencing, depending on what happens with the trial, if we would pass sentencing until we resolve the other ones.
Right.
We'll figure that out as we go, I guess.
Okay, but Mr. Jordan needs to understand that, to decide whether to accept it or not. Mr. Jordan, have you had sufficient time to speak with Mr. Cobb about the score sheet?
Yes, sir, I know what I score out to.
Okay.
It's all my juvenile.
Okay,
All my stuff is from 1989. I've got 2 felony convictions since 1989.
okay,
You know, I served 18 years in prison for that. I understand that. I did that.
okay,
I bear that burden, but from what happened to me in this county in 2023, when I was brought from Santa Rosa County Jail and held in Okaloosa County Jail for 10 days with these same 3 warrants pending for my arrest. And Brooke Davis, the assistant state attorney, did not. She advised Okaloosa County Jail warrant officer not to book me on them warrants. When I was brought over here, I was brought before your court, and I had a felony case for FTA in this case right here. And they kept me in that jail for 10 days and would not book me on my warrants. They violated my constitutional rights of due process.
okay.
Majorly. And this woman hasn't even been, y'all haven't even sent this to the Florida bar against her or nothing. That woman went out of her ministerial duties as a state attorney and had that done. That's wrong.
Judge, I've talked to Mr. Jordan, and he has brought up pre-arrest delay issues with regards to all of his cases, and I've researched it fully, and as his attorney, I've advised him that he does have a good faith argument for pre-arrest delay in the 23 cases, but I do not see a good faith argument how any type of pre-arrest delay prejudiced him in the 21 case, because he was arrested in the 21 case, went to jail in the 21 case, bonded out, and then got arrested in Santa Rosa County, which led to an FTA, which the state would not proceed with because they had found out now he was in Santa Rosa County.
Understand.
I tried to explain that to him, and I've researched any issues with regards to the warrant. I've exhausted possible pretrial motions with it, and we just have to sit it for trial, Judge.
Okay, so we're set for trial. Are we going to trial next week?
Yes, Your Honor, I'd spoken with Investigator Richards, and I think Friday is the date that we would.
May 31st?
Yes, Your Honor.
Okay. So, Mr. Jordan, you do not wish to accept the state's 6-year offer, correct?
No, sir.
And that was kind of a double
I can't
negative.
honestly do that, and I go to prison, at least I'll have at least a shot to get back on appeal. I mean, it's because out of all the cases I've read, that if the state intentionally delays, you denied, or no, you dismissed my writ of habeas corpus on 2 grounds. One, because I amended it, and I had a lawyer when I amended it. And the other ground was because you said that I was legally being detained because of an FTA warrant for failure to appear. And then were 2 reasons you dismissed my writ of habeas corpus, and I just can't see that.
Okay.
They intentionally delayed the execution of these warrants, and
Just for the court's awareness, that offer that we did with the 6 years was going to be dismissing at least one of the 23 cases, so that would alleviate at least that concern on one of the cases, if that's what he has.
Okay. How many do you want on the veneer?
I think 35, Your Honor, just with this having a firearm.
Okay.
Yeah, I normally
Okay.
ask for 40, but 35 is good.
Let's do 40,
Okay.
Your Honor, just to be safe.
Okay.
what's that?
40 people, jury, an hour, 40 people will be, pick a jury.
So, Mr. Jordan, I'll see you back here on May 31st. That's a week from tomorrow at 8:30, and we'll be going to trial. Okay.
When would we pick the jury, Judge? On the 20,
That-
would it be on that day?
Yes,
We're
sir.
gonna pick and go?
Pick and go, Your
Correct.
Honor.
Oh, okay.
Okay.
That's good.
If we can set just a deadline for any motions, pretrial motions,
That's fine. I'd have the typical motion in limines with regards to hearsay, all that stuff that I'll file.
Okay.
And I'll file those by Tuesday, if that's all right.
that's okay with me. And then if we need to hear it, are you available maybe Wednesday?
And you're in charge of my docket at this point. We've got, on Wednesday, we've
Wait,
got
are you-
Robinson going.
Are we doing Thursday for any potential motion and limines for Mr. Snell's case? If so, then we can just knock it on, we can add it onto that.
That would be fine.
No problem.
and hope that y'all don't set a jury trial for May 30th, but we'll see.
This is all I have, Your Honor, so.
Okay. Okay, so I'll see you at that motion hearing, probably on May 30th, and then we're looking at going to trial on the 31st, a week from tomorrow. Thank you, sir.
Shannon Martin, number 3.
Thank you. Hello, Mr. Martin.
Judge, this is Shannon Martin, present for the court. He has 2 cases.
Yes, sir.
I know that he was evaluated by Dr. McDonald. Dr. McDonald did find him incompetent to proceed and recommended that he be treated for psychotropic medications. But I know that Mr. Martin does not agree with that.
Sure.
I've been in correspondence with him, and he doesn't think he is incompetent. He doesn't think there's anything wrong with him. He definitely doesn't go back on any type of psychotropic medicine. So, you know, I'm not a doctor. I will admit and stipulate to Dr. McDonald's report because she's the professional. That's her opinion. That's what she stated. I have no desire to cross-examine her about the accuracy of the report because I've read it, and that's above my pay grade. But Mr. Martin definitely doesn't agree with it.
Understand. Does the state have any objection to the doctor's evaluation?
No, Your Honor, we would move we would stipulate to that evaluation, Your
Okay.
Honor.
Mr. Martin, I do find that you're incompetent to proceed, so you'll go to the Florida State Hospital. It says that you should be back before the court within 6 months or 12 months.
Well, sir, Article 1, Section 24 says that I refuse medical treatment. I mean, I don't need no medication. I mean, yeah, I understand everything that's going on. I mean, they can't force medicate me for no reason, and that's what they're going to do at Florida State.
Well, Mr. Martin, it sounds like that the quickest you'll be back to the court is if you follow their, their requirements, whether they can force you to take the medications or not. I'm not making that determination at this point, but it sounds like your quickest way to get this thing resolved, this case, is to follow their advice. So hopefully you'll be back in 6 months.
The state kidnapped me. I mean, they sent me to Fort Walton Medical Center. I mean, under the Baker Act, I checked. I mean, I got the docket sheets. There was no Baker Act done. I mean, I was diagnosed with 2 psychiatrists. They asked me where I was going. I said, the state of Tennessee, 2076 State Route 18. They said, well, good luck. I mean, it was done right here in this court, Okaloosa County, this courtroom, Crestview. There's no paperwork on it whatsoever. I mean, they kidnapped me and sent me to Fort Walton Medical Center, and they would see me there, and they said, we're going to put you under, let you go. And they took me to the bus station, put me in a Hoover car and sent me to the Fort Walton bus station. They gave me a debit card, said it was from the state. I get to the Fort Walton bus station. They said, we don't have no ticket here for you today. So what am I supposed to do? I mean, I've been kidnapped. I mean, bottom line, there was no Baker Act done. They had no reason to send me to Florida State. Fort Walton Medical Center for no reason. I mean,
Okay.
They broke their own policy.
And Mr. Martin, you're not here before this court on anything.
That's their policy. When you flatten a sentence, I flattened a 55-month sentence.
Okay. Mr. Martin, they'll take you back and you'll go to the Florida State Hospital. Thank you, sir.
Martin, come on up.
That's not right. I'm checked.
Deputy, you need that story?
Thank you.
This is Jason Cobb on behalf of Ms. Scully. Judge, I look at my docket and I find cases I think I can resolve fairly quickly to try to resolve things. And I thought I could get this one resolved fairly quickly, but it turns out this case actually kind of belongs in Judge Ketchell's division. And Mr. Snell's filed a motion to have it transferred because a co-defendant's case is being prosecuted
There's
Is
three.
is this one that has a lot of different
Three
co-defendants?
co-defendants already in that division, and so, I just submitted an order.
Okay.
Back to you.
And during the last break, I was talking to Judge Ketchel about scheduling and did he have those, and he brought up about co-defendants. Ms. Scully's case wasn't brought up particularly that I'm aware of. He was just talking in general. They started talking about trial, and I said, gosh, I can't remember the last time I've had co-defendants tried together, but then I kept thinking, and I said, wait a minute. But for discovery purposes, it would seem to be better and more efficient to have the same judge for all the discovery instead of having different dates from two different judges. And then that made sense to me. So Judge Ketchel has co-defendants that the case numbers are less than this?
Yes, sir.
Yes.
Okay. So the motion to transfer is granted. So Ms. Scully, you'll appear in front of Judge Ketchel. Okay.
And then the same stuff I've been doing with Mr. Snell, I'll get in touch with the prosecutor and Crestview. Well, whichever prosecutor, not Crestview, it's
Ms.
still
Sharpless.
I'll get in touch with Taylor Sharpless, Ms. Sharpless, and we'll get it resolved, okay? All right, hang tight.
So
Thank you, ma'am.
her new court date's gonna be June 12th, that's his pre-trial.
June 12th.
Good. Thank you.
I'll go look, I'll make sure I remember it really quick. I think that's all I have, but I did have one question. About the Amy Mayhew cases, I've been getting, it's State versus Amy Mayhew. It's a recent arrest. I was recently appointed by you, and it's scheduled for detention status hearing at 12:30 today.
Okay.
But then it's also scheduled at 1:30 for
Arraignment?
arraignment, and I filed a written plea of not
Okay.
guilty, so that should kick it out of that.
It should, yes, sir. But I'll see you at 12:30 on the detention.
Yes,
I'm sorry, the Major's detention is in front of Ketchel
at 12:30.
at 12:30.
Okay,
So that was transferred to him? Okay.
see, that's why I was
It is,
confused.
that whole thing is chaotic to say the least, but yes, it is in front of Judge Ketchel. I'm gonna need to come and handle Miss Mack's case here in front of you, Your Honor, and then I'm gonna run over to Judge Ketchel's courtroom.
Okay.
Is it going to be in Judge Ketchell's division, or is he just handling the?
It is probably going to be in Judge Ketchel's division.
Okay, that's what I was confused about, because you signed an order appointing me, and
Okay.
that's fine.
You know, speaking with Judge Ketchel, our intention wasn't to cover anybody else's, docket. But if it's more efficient because of co-defendants, it would seem to be one judge would be better.
Yes, sir, I agree totally.
Okay.
I think it's more of just a clerical thing for us that we have to get it actually moved into the other division. There was quite a lot of co-defendants, and we were trying to figure out what attorneys were going to handle what, because there's just a lot. But I do believe it's ultimately going to be in front of Judge Ketchel.
Okay. Okay. Who is the defendant?
Ms. Amy Majou.
Okay. And did he want-
I don't know what they're doing, Judge. Number 2.
Okay. And I haven't done homework for that. Okay.
All right.
She's also an inmate, she's downstairs. She's not up here.
Okay.
All right,
Thank
then
you.
I will not see you at 12:30. I'll see Judge Ketchel at 12:30, and that's all I have. I'll see you next week.
Sounds good, Mr. Cobb. Thank you, sir. Okay. Who's next?
If we could do someone for 1:30.
Okay. So everything's, Madam Clerk, everything's off at 9 o'clock?
I've got some minutes left on mine.
Okay. Who?
I have Jennifer Rompalo with Mr. Koch.
Mr. Koch? On the bottom?
I just approved in all process.
So you're dismissing that case?
Yes, sir.
That case is
Yeah.
dismissed?
It took me a while to confirm, her
Yes.
status, so.
Good.
I have Seymour Short with Mr. Koch.
We talked about him yesterday, Thomas.
Yes, this was this morning afternoon.
23.
Thank you.
That's gonna be a normal process for 23 CF 1856.
That case is also dismissed.
It's the victim request.
I have Justin Lyons with Mr. Lyons.
Your Honor, Mr. Lyons was transported this morning. He's in the county jail right now. If we could put just Mr. Lyons' case on June 13th for the status, He was transported for potential drug court treatment.
Okay, good, yes, sir.
That's all I have for the night.
Great, okay. Rachel, who are we doing from 1:30?
We'll start with Jason Smith, Mr. Fox, she's number 16, Level 3.
So when am I going to learn about the homicide case?
This afternoon.
This afternoon, there's a motion amending, Ms. Sandler will be present then. and-
Okay. And so then no more trials are scheduled for next week, other
Yeah.
than Robinson on Wednesday, Jordan on Friday?
That's correct, Your Honor.
And no way, because of the officers, no way to move Rollison or Smith to next week versus June 3rd?
To my understanding, that is correct. I think there's multiple officers that kind of took advantage of the holiday week and I think are not available.
Okay. Okay, just, you know, I will send out at lunchtime and ask if there are any judges that can cover any of those. I'll let you know any update this afternoon, late, and tomorrow. Okay?
Thank you, Judge.
Good, thank you.
Yeah, the homicide case, I believe, is going to take the jury the second week, Monday, and it's going to be a multi-day trial. I'll defer to Sandra when she's here at 2:30.
Yes, sir.
Likely be asking for 140 jurors, for any seconds.
Okay, thank you. Okay, yes, sir.
Judge, I got Mr. Jason Smith. Let me see that, make sure they give us the right. Yes. Your Honor, we'll be entering a not guilty. Waive formal reading. It is set next for July 8th, but I did talk to my client. We're trying to work it out, and I could certainly bring him in sooner
Good.
if we reach upon a deal.
Mr. Smith, I'll see you no later than July 8th, but if the state offers you something that you want to accept before that, Mr. Cox can set it for a hearing next week or after that. Okay? Thank you, sir.
Yep.
Carrie Stone is next, number 17, also.
Thank you. Mr. Stone, how are you doing?
Good, sir. How about yourself?
Doing well, thank you.
Sure. This is receiving the two-count information. I will be entering not guilty, waive formal reading. I'm asking it kept being set for the 7/8.
Okay.
My client does have multiple cases. This should be the last case they filed on. So now we can do discussion with that global offer that we've talked about.
Yes, sir.
Good. Mr. Stone, I'll see you no later than July 8th.
Yes, sir. Thank you, Judge.
Thank you, sir.
Michael Walker is next, number 19, Level 3.
Hello, Mr. Walker. Mr. Walker, you don't have an attorney for this case or these two cases. Do you wish for me to appoint a public defender if you qualify financially?
Yes,
Okay, how much money do you make per month?
I was making about 2,500,
About 500?
2,500.
2,500? When's the last time you've worked?
I worked in this year.
Okay. Mr. Walker, you'll need to fill out a financial affidavit. I would recommend or suggest to you that you load that up with expenses if you have different expenses. If the clerk says you do not qualify financially, there's a place for you to appeal it to a judge. We have more latitude than the clerk does. So if we look at that and say, looking at the totality of Mr. Walker's finances, he can't afford an attorney, then we could still appoint a public defender to represent you. But just based on that figure, I can't do it today. So I'm not appointing an attorney today, but fill out a financial affidavit, okay? Mr. Walker was provided with the information. Okay. So, Mr. Walker, I'm entering a denial. You're charged with petty theft and resisting an officer without violence. 2 counts of petty theft, actually. And that's the paperwork that you've got, the information, the charging document from the state. So that's why you're in jail. Fill out that paperwork. If you don't qualify for the public defender, you'll either be representing yourself or you'll need to hire a private attorney. But again, fill that out, appeal it to the judge, let us look at it, okay?
Okay, I asked the jail for that financial form 3 or 4 times, and they still didn't give it to me. And then the last time, they said the supervisor was gonna bring it, and they didn't.
Okay, and what is
They just
that?
wouldn't
you-
answer talking on the mic.
The application, Judge.
Oh, okay. Do we
Yeah,
have
to
a,
fill out for the,
Okay. Good, we'll give you one now,
okay.
okay? Is there any offer from the state to Mr. Walker at this point?
24 months, Department of Corrections.
Okay. Mr. Walker, I'll see you back here no later than July 8th, okay?
Okay.
Thank you, sir.
That's all we have for right now, Judge.
Okay. Yes, sir, Mr. Cott?
Judge, it's on the 230, Mr. Mitchell Smedley and 23 CF 632. Speaking with the state yesterday, and we were going to announce a no problem. Smedley.
Yes, Your Honor, this time, the state would announce Mall Cross and 23 CF 632 would not be able to approve that case beyond a reasonable doubt.
Okay. 23 CF 632 is dismissed. Good. Thank you, Mr. Cott. Okay, so we're in recess until 12:30.
Judge, does probation need to be here for the 12:30?
No, ma'am.